Hey, everybody. Welcome to the Trust Conference Room high atop the 1616 Camden building where PGW is located. We just had our all hands meeting for March. And so whenever we do that, it's just too tight to get back to my home studio. So this is where we're at. We've got the ever wonderful Jack Santaniello joining us, and Adam is on a break today. So, he kind of wore himself out, I think, after all that tax stuff back to back. So anyway, I do have a tax little interesting thing before we go into what's happening with intellectual property and knowing your rights as well as your risks, because there are both. And so Jack is ready to go and go headlong into that. You guys know the drill. Hit us with the Q&A for questions. If you want to harass us on the chat, that's always welcome too. And also, yes, I am wearing the Charlotte Football Club, I call it the grape jersey, but it's the royal purple. And this isn't jersey. This is from 704 downstairs. But what a disappointing loss. Oh my gosh, to the Revolution. I was so bummed. So anyway, here's the little rant that I'm sure Adam would want to talk about. It's kind of interesting though. So Supreme Court ruled last week, are all attendees eligible for the gift card? You've been hanging with us for a while, man. That's hilarious. It completely comes down to the generosity of Shumaker and how many are on here. I think there are too many on here though. Sorry, man. But here's the ruling on Tuesday. 5-4 case involving a Romanian American dual citizen who failed to report millions of dollars in foreign bank accounts. All right. So, but what's interesting, so the question was, hey, did he violate the Bank Secrecy Act by failing to disclose the funds? The court ruled in the taxpayers' favor. Woo! Whenever they rule in the favor of taxpayers, I'm doing happy dance. But it was 5-4. The weird thing was, no, it wasn't on conservative liberal divisions that you would expect. Neil Gorsuch, Samuel Alito, Brett Kavanaugh, John Roberts, and the new Justice Jackson voted for this. And what's interesting is Clarence Thomas, who's very conservative, Amy Coney Barrett, as well as typically she's kind of more middle of the road, I suppose. Sonia Sotomayor, I always screw that, sorry, and Alina Kagan all voted in the dissension. Sorry, I'm in this room and I have to move around or I lose my light, which is ridiculous, but it is what it is. High atop 1616 Camden Road. All right, so that's all I had with regard to tax news. We'll go deeper into this whole intellectual property. So Jack has some slides. He might have some gift cards. I don't know. It's up to him. So, and also just because we're going down this path, if you've got questions, especially from a legal or business growth perspective, if you're going to go deep on tax, I am not your guy. That is Adam Boatsman, not me. So feel free to hit us up with those things as well. All right, Jack, the floor is yours.
All right. So good morning, everybody. I am also not Adam with tax expertise. I will give you Jack theories and dad theories all day long. So feel free to launch those, but you accept those comments at your own risk. When we were talking about amongst ourselves as to something to bring up and talk about, it just seems like talking about intellectual property, trademarks in particular, was a timely topic. You have things coming up with the name, image, likeness issues, and you hear about all that stuff in the news. And then, just generally speaking, it's a huge asset to a business. And I think that maybe 15 years ago, banks, and not to speak for any bankers who may be on the line now, but in this moment, but I think they would probably agree that the intellectual property of a business, meaning the trademark, the logo, et cetera, really, there wasn't a whole lot of value placed on that intangible asset, because how can you put monetary value associated with that? How can you use that as collateral for your the loan that you're about to give to a potential business owner? So it's those kind of things. And I think the evolution of the intellectual property asset and trademarks in particular. So we're talking about know-how and those kind of things, but specifically that thing that identifies, and we'll talk about what the definition of a trademark really is, what identifies your business and you as the owner and you running that business versus someone else's business. So I'm going to launch right into it. I do have, this is a derivative of a PowerPoint that I do in relation to just general topics, general business topics. So I'm going to see if I can share that screen. Okay. Can you see that screen now?
Affirmative. Yeah.
Affirmative. All right. Let's see if it's going to let me start.
Yeah. There
All
you
right.
go.
Perfect. All right. So trademarks. So here is the, and this is obviously, this is an older slide from when Deal or No Deal was in the mainstream, but I like it because it brings up it makes a very good point. And so here's a little story for you. In September 1998, these two university students who were computer science grads, and this is more of a question, let's say if you're a banker, approach you for a loan and present you for your review what appears to be a sound business plan, which is confirmed by your own due diligence. Part of the assets they propose to pledge as collateral are the new technology and intellectual property, including the trademark application. Now, understand this has not been filed, has not been registered with the feds, with the USPTO yet, associated with a new service for online advertising and internet searching. Now, this was in 1998. So the first person in the next 7 seconds that tells me what company this is, I will give a certificate to. So the clock is ticking.
Ooh,
and I can't
right.
see the chat because both of my screens are taking up the slide deck. But if
Well,
anybody answers,
Ryan, it's time to put up or shut up because he was asking for free gift cards. So
there you go. All right, time's a ticking. All right, so
oh, Bruce.
did Bruce get
Bruce
it?
nailed it.
You really? Okay. So Google, imagine that. Okay, two kids saying, hey, we got this business concept, okay, an idea, and we have this mark for it. This is what we want to do. So, all right. So the history of Google, 95, these two guys meet for the first time. 98, they file an intent to use federal trademark application. We'll talk about what that means. Basically, well, let's talk about it now. What it means is that in the US and not in all jurisdictions around the world, you can basically say, I have an intent to use this mark. And so you kind of reserve your rights, and then you have a period of time to prove that you actually use it. In many other jurisdictions around the world, it is you have to have that mark in use in commerce before you can ask for essentially a monopoly on the use of that mark for goods and services, whatever you are selling. All right, in May 2000, the first 10 language versions of google.com are released in those various languages. So very short period of time in the scheme of things, but I mean, it's how quickly technology can happen and evolved over the course of time. And note that it was 4 years after the launch of these foreign language versions that they actually got their registration granted. So the reason why I also point that out is it's very important to protect your rights earlier than you might actually think you should be protecting them, or even you're able to protect them. So we'll talk about that some more. So
Jackson,
what is a trademark?
Why
Yes.
did it take so long? I mean, we registered anything but typical, and I think we were granted that registration within probably 6 months.
Yeah, the gestation period before you actually hear anything is usually 8 to 9 to a year potentially. The reason why this took so long, in my understanding, is that they had to prove the concept in use. So basically, when you ask for this federal monopoly that is granted to you, you have to show that it is in use for everything that you are asking for it to be protected. So imagine that if Google, and this is Jack theory, let's say that their first foray into the public was their translation program, okay? And it really wasn't a huge search engine back then, and they filed for a search engine, but it hadn't been fully developed, then they would have filed an intent to use for that. So that's why it takes so long. And you have the feds that are reviewing the application and saying, okay, are you actually using this? Are you using this or not? And it's a way for them to not grant a monopoly for a mark or a business that never comes into existence, which happens. And we'll talk about that. It's a 10-year registration, but in the first 5 years, you have to file something with the U.S. Patent and Trademark Office, or else they will take you off of their books and allow someone else to use that mark. So, all right.
Preventing
So
the squatters from like what happened in domain names back at about that same time, right?
exactly. Yes. And that is a whole nother topic of conversation, cyber squatting and all that went on, and preventing that, and, people holding certain names hostage, trying to get a payday. And very early on, they were getting their paydays until the Fed and the state governments came in and swooped in and said, yeah, you can't do that. So what is a trademark? Protects words, names, symbols, sounds, colors that distinguish goods and services from those manufactured, sold by others, and to indicate the source of goods. That's a key component. Okay. So the trademark is not necessarily saying this is a wonderful, whatever it is, good or service. It is saying that this good or service is sourced from this particular owner that is located in Charlotte, North Carolina, has been doing this for so many years. So that is what you're protecting, essentially. And that is what the federal government is granting monopoly on, and not allowing others to use it. Okay. So trademarks basically can last forever, so long as you're using it in interstate commerce. Whereas patents have, and you can extend the life of the monopoly via a patent, but it's not forever and ever. At some point, it becomes okay for other people to use your process that you have patented to make whatever it is, because it's deemed to be in the best public interest that others have the ability to do that. One of the biggest industries in that regard is the pharmaceutical industry. It's the reason why we have a lot of generic drugs, is because when the patents run out for those particular formulations of medication that have been patented, then others who can produce it via that formula, maybe at a cheaper amount, are able to do that. So for the betterment of humankind and society. So that's how that works. So you essentially have 4 types of trademarks. And maybe this is kind of stating the obvious, but generic is the common household name for products or services. You can't protect those things because you have to use those words to describe whatever it is. It's kind of like that game password, where you can't say certain words, or $100,000 pyramid, that you can't say certain words as you're giving clues, kind of thing. It's that kind of concept. You cannot give somebody a monopoly on those words. And then, so originally Kleenex instead of facial tissue, Xerox instead of a photocopy or machine copy. And Xerox is, so those kind of things became generic because Kleenex and Xerox allowed those things to be used for facial tissue. So it's like, hey, can I have a Kleenex? Well, it's not Kleenex brand, it's facial tissue. So those kind of things can become generic if you don't protect them, which is something else we'll talk about. Descriptive, you kind of know what it is, or you have an indication of what it might be, but you have to acquire what's called secondary meaning, which is that it is, okay, it's that person that is doing that thing in Charlotte, North Carolina, and has been doing it for a period of time. So when we hear that, we know it is that company that is there doing that. Suggestive is kind of the next step down, which is In order to link the mark to its function, you have to be somewhat imaginative. It's protected by trademark law, even without secondary meaning, so that you don't have to become well known for that. And meaning you don't have to build a reputation in that product or service in order to get that monopoly. And then arbitrary and fanciful is basically stuff you made up. Kodak has nothing to do with photography. It's and somebody made it up. So that's how that works. For descriptive marks, what happens, and the way I describe that is that you can file for protection. You don't get the full amount of protection. So imagine you try out for the varsity team, you get put on the JV roster. After a period of time, you work your way up to the varsity team. And so it's kind of like that. You play in the junior varsity league for a while with providing your goods and services. Eventually you're able to say, hey, I've been well known enough to get into the majors or varsity team. So you get promoted to the varsity league, essentially, or varsity team. All right. Some examples of the types of marks. So you can't trademark salt. You can't trademark Apple. Vision Center for eye care. You would have to put something around that, whether it's some sort of logo or put something else in front of it with a name for that to be protected initially, but eventually, like for example, if you were to use Metroline of something, you may be able to get protection for that because it becomes distinctive over the course of time. Blu-ray for CD data storage, Mustang for a car, arbitrary and fanciful, Exxon for gasoline, Apple for computers. So again, the same term could be generic for one thing, but arbitrary for something else. And then you have marks that are, Apple, and let's say that it's not fruit, it's not necessarily technology, but it's somewhat how related to technology. Like if someone were to sell you, I don't know, a charger or a stylus and call it Apple something, that's not going to happen because they've become so famous, or that something even unrelated. So sponsored by Apple. I think Apple would have a problem with that because then you make an assumption that Apple Computer Company is sponsoring this. And so they would likely send their attorneys after you if you were to do something like that. All right. So let's talk about some trademark issues. Federal registration, how does that work? So basically we do a search to try to figure out if there's going to be problems associated with your application. You don't want to find out down the road that someone in another jurisdiction, even if, let's say, I don't know, Virginia, DC, New York, or even cross country, is using your mark that you want to get a federal protection for. And so we do a search and we try to give you better odds at being successful in getting through the due diligence that the federal agents do on your application. And so what happens in that instance is we file we do the search, we report back to our clients and we say, okay, there is this company in Florida that is using this mark for this purpose. It's similar to what you want to use it for, but here's how we might work around it. Not 100%, but here's how I work around it. Or in other instances, sorry to tell you this, you're dead in the water. Someone else already thought about this. And as soon as you file for this, the USPTO is going to say no. Or if it does slide through, there is a high probability that if that other company finds out, they're going to send you a cease and desist letter. And it usually happens after you've spent many tens of thousands of dollars or more in marketing, business development under that name. And that's kind of problematic. So we do that, and then it moves forward, and then it goes through the federal trademark process, which is a USPTO person. They're called law examiners, but they're not all lawyers. We'll look at the application and they will try to find, let's say this, I shouldn't say it that way. Their job is to review what is already in their system to see if there is someone else that is using a mark that is the same or similar to your mark, which creates a likelihood of confusion. And the likelihood of confusion, going back to what I said before, is the confusion that that mark that says, I don't know, highlighter. Okay, this is interesting. So I have a highlighter and it's spelled Liter. So, and it has a little R in a circle. So it's federally registered. All right. So if, let's say I was applying for a mark that was high, lighter, Leiter, for bizarre example, but the USPTO examiner would say, yeah, sorry, phonetically equivalent, we're not going to let you do that, because if you are producing your highlighter Leiter in Charlotte, North Carolina, well, there's easily confusion with that highlighter Liter company that produces their product wherever it is. It's an Avery product, so wherever Avery is. And so that is what the likelihood of confusion is. It's not necessarily related to the actual product. It is where the source of the product is, in that, okay, I really like Avery products, so I see highlighter, oh, that must be an Avery product. And you find out, no, it's some product that is doesn't highlight as well, bleeds through, it dries up quickly, those kind of things. So there's tarnishment. State law registrations are mostly useless. They work only, they're useful only in a case where you're trying to beat someone to saying that you have a registered mark and it's registered with the state, but really that doesn't help unless you are only doing business in that state. And the main reason why that's not helpful, many businesses are on an e-commerce platform or have sales outside of their state. So for example, when we're 10 miles away from the border, at least in uptown Charlotte, you go to South Carolina, as soon as you cross that border and you have a North Carolina state registration, that's not going to protect you. You've probably heard of common law rights, and that means, so for example, I have the highlighter mark, Leiter. I've been using that for 25 years in Charlotte. My grandfather started the business many years ago here in Charlotte. And then Avery comes along and they they have their federal registration, and they for highlighter Liter, and they start putting it in Office Depots and other places here. Even though I do not have a federal registration or state registration, I have common law rights, and I can go to Avery and say, get your stuff out of these stores. Now, practically speaking, good luck with that. Avery's a big company and they're going to spend a lot of money on attorneys and suck you dry and attorney's fees. So that's likely not going to happen. What will likely happen is Avery's going to say, hey, okay, we get it. They're going to fight it first, or they're just going to be efficient and say, we're going to pay you a ton of money to basically sign a release and a settlement that says you're selling us your common law rights, and therefore life goes on. So if you're in that lucky position, well done. And, I'm happy to be your attorney in helping write out that negotiated settlement for your many millions of dollars that you would get paid for doing that.
So got a question in there.
Okay.
Oh yeah, this is really, what cost investment would I expect to incur to have a trademark done on the name of a business?
Okay. And I'm going to answer that question, but I wanted to, and very timely question. So one of the common mistakes or misconceptions is the next thing that's on the list, an entity registration. And I don't know, I can't see who asked that question, but whoever asked that question, again,
Robert Mayetta.
Okay, Robert. So you understand what I'm about to say. So that the fact that you ask me as your attorney, or you go ahead and file the name with the North Carolina, South Carolina Secretary of State, there is this preconceived notion, misconception that then I have intellectual property rights to that name, which is not true. Those are separate and apart in that you file with Secretary of State, you're domiciled in the state of North Carolina, and you get the privilege of paying taxes and everything else, but that doesn't mean you have intellectual property rights. And so what you do have to do is take that name and seek intellectual property protection for that business name. Now, the process, as I alluded to before, which is step one is to do that trademark clearance, and step two is to do the application. And typically for us, it's about $1,500 plus the application fee, which is like $325 to do the search, and then about another $1,500 to do the actual application. So you're looking about a $3,000 investment for a trademark. If it's a mark that is kind of a bet the farm kind of mark, then you have two options with that on the front end on the search. We can commission a search with the company who we use their software. So when we do our own searches, we use the same software, but what they do is they have a broader reach and net essentially. So they will look at domain names. They will look at Wall Street Journal articles, and they'll say, okay, this name was mentioned in these various places. What do you think about that? In addition to their federal trademark registration and their application search within the USPTO database. Our searches that we do internally are focused solely on that database, but they are phonetic variations. They are translations. So the Spanish word for whatever it may be, which is kind of funny. So, all right, here's a little tangential story. I have a client that is in the conveyor belting business, underground conveyor belts, mining essentially, right? And they wanted to use the name Metallica, but in the Spanish word for metal, and to use it for a conveyor belt, which again, even though they may be transporting metal, metal for a conveyor belt, when you hear the word metal, did you think conveyor belt? No. So that's why you're allowed to do that. And so got a cease and desist from the owners of the copyright for the Metallica band. And I was authorized to push back a little bit, but only a little bit. And I pushed back and I said, this is ridiculous that, there's no one's going to think that the band Metallica is in the business of underground mining. Yeah. And they wrote back and they said, we don't allow anyone to use it. And I did do some research. They sue everybody. So they have people now, software, that anytime someone files anything related to metal or Metallica for anything, that they go, and that's a famous mark. Coca-Cola does the same thing. Nike does the same thing. And so I went back to the client. I said, how important is this for you? And how much of a bankroll do you have? And they said, well, it's for a product. It's not a bet the farm. So we're just going to change the name. I'm like, great choice. I'm happy to take your money on attorney's fees and fight a losing battle, but they made the right choice in order to do that. And so that demonstrates the concept of a famous mark, that demonstrates the concept of what normally would be okay, because even though it's a common word, it's not being applied to something that is normally associated with the word. Another example was there was a restaurant in South Charlotte in Valentine Village called Table. And when I filed that trademark, the USPTO gave me a hard time because it was, well, table restaurants, you have tables in the restaurant, so we're not going to lie. I'm like, that is the stupidest explanation. And I went back to the examiner very kindly and I said, yeah, and I had the research and I went back to him and he still resisted. So then I had to go and appeal it to his boss, and she was a veteran of the USPTO and granted it. Table sister restaurant, Blue Restaurant up here, same thing. They came back and they said, well, restaurant, Blue, Pabst Blue Ribbon beer, you serve beer. And like, if you've ever been to Blue or ever were to Blue, they don't serve Pabst Blue Ribbon. Nothing against the beer. It's just that they're serving all the fancy stuff and wine and everything else. And so I said, yeah, that's ridiculous. So I went back to them. I was actually expecting them to say maybe Blue, not so much, because Blue Mediterranean, it was a Mediterranean food restaurant. So I thought maybe they give me a hard time with that, but that wasn't the issue. So, but that's long-winded tangent way of saying that's the process and the cost. Typically, at least for us, there are people out there that will charge you a lot more. There are people that will charge you less, but this is one of those scenarios where you get what you pay for. And so you want people that are doing experience, that are looking into the right places and formulating that search algorithm properly with the right words and looking in the right places to make sure to give you a better chance. Nothing is foolproof, but we get you as close as we can. So and then, yeah, go ahead.
Jack, we got another question in from
Sure.
Robert. How much in attorney fees does it cost to defend a trademark? Depends.
Yes. Very legal answer. It depends. So I don't necessarily like telling war stories, but I think in this kind of environment and this topic area, it's appropriate. So I send out the nasty grams that say that while it is likely that this was inadvertent, we wanted to let you know we have this, that my client has this trademark registration and we'd like you to stop. And sometimes they'll come back and say, oh, sorry, but we've spent a lot of money on this. It's like, okay, well, I'm sorry. Quite candidly, you should have had an attorney that would have found this very easily and told you to do something differently. But, and if we can work it out and we say, how much of a runway do you need to make a transition with that mark and to something else? And usually we're able to work it out. Sometimes we end up with a license arrangement. Either we as the trademark owner or as the infringer, we find an arrangement. And I've had to work that out. A couple of years ago, I had a client that chose a mark that they should have known that was going to be a problem. And it wasn't Reebok, but the backer behind this company was Reebok. And so I went to the client and I said, okay, we have a small problem. And what do you want to do about it? And so I was very much negotiated. I was surprised. I mean, Reebok could have said, you knew it, you should have known it. It was willful infringement, not unintentional infringement. And so we're going to hit you with all these damages. Instead, they took a much kinder approach and said, okay, here's what you need to do is you need to remove the logos from everything over the course of time, transition the business. It was a membership organization. So you got to get your members to, turn in their membership cards and reissue new ones. And there was some equipment that I said, well, can we just, and I showed them, I took sandpaper and it was on leather and I was able physically, I mean, it looked ugly, but at least they didn't have to get rid of all of their inventory immediately. And it gave them a little, it showed that we were willing to do that in order to resolve the situation. So the cost really just depends on how aggressive, assertive, cooperative each side is really. So there's no way to handicap that.
Hey, Jack, I don't know if this is an urban legend or not, but isn't there some precedent that if you don't defend your stuff, that it sets a precedent so that it weakens your ability to defend? Is there any truth to that?
That is very good. I didn't even share my notes with you about this. So yes, absolutely a wonderful question. So yes, you are required to use the mark in interstate commerce continually, and you're required to defend the mark. And so, for example, in the ones that I showed you before with Kleenex, that they didn't defend it. They allowed people to use it and they didn't think anything of it. And now, their protection is very much weakened and they can't go after, you're not going to find companies that put Kleenex and try to sell the tissues. But if they were to use, hey, come use our Kleenex tissues, like in a commercial or something, it's harder for Kleenex to police that. So yes, you need to do that. I'll give you another interesting example. So if you ever leaving town on an American Airlines airplane, and you happen to be, as you're boarding the plane, and see physically on the side of the plane, you see the US Air logo, you see the Piedmont logo, you see, I think, Allegheny and some others, you're like, oh, that's cool, nostalgia. And oh yeah, I had forgotten that American over the course of time and US Air had just, gobbled up all these airlines and continued running them. And yeah, that's true, but there's a business reason for that. And that's because every time they have that plane fly across state line and use it in interstate commerce, they are using it and therefore protecting it. And therefore if anybody has a problem with it, they are protecting it defensively so that no one can start an airline, a Piedmont airline, a US Air airline, et cetera, because they have not lost the monopoly that they have to use that. Right. So next time you see that on the plane, now there's really a business reason for that, not necessarily that it's nostalgic or anything like that. So yes, you do have to police your mark. And so, there's, and the other thing too, that is an issue is using the mark beyond what the protection is for. And it's easily done through the organic growth of your business, in that you kind of forget that the trademark that you have was filed for specific goods and services. You continue to grow, you go into new lines of service, et cetera, but you don't file an application. The way the registry works is that it is done in what's called international classes. And I don't remember the total number. There's like 48, 49, maybe it's above 50 now. But so you have goods classes. So it is, chemical goods, it is paper goods, it is everything that you can imagine fits into one of these categories, these classes. And then you have the services classes, and you have a catch-all for both of those if something doesn't fit into one of those classes. And so, internet advertising, and, whether it's done paper advertising, internet advertising, those are separate classes. So again, the evolution of technology, I see when I go through due diligence on buyer side, I see that seller has this trademark, but they're doing all these things, but the trademark is only registered for one of the two things that they're currently doing. So we got to fix that very quickly so that we don't lose protection that we thought we had. And let's go ahead and let's make sure that the seller pays for that instead of my client buyer kind of thing. So, purchase price adjustment, those kind of things may happen. So, and one of the other things that I want to talk about is cybersecurity and how I see that happening. So we have a very good cybersecurity law group down in our Sarasota office, and they focus on both preventative, so being assertive, but also defensive and dealing with some things that happen. And a lot of times what we see happening is the low-level intrusion into a business where you have people finding out passwords for the lower levels of management or employees, and they very patiently work their way up into the higher echelons of people in the organization that have access to. And then once they find what they think that they can monetize in information, data, et cetera, that's when you see the breach. The reality is that the breach has been brewing, and the breach actually occurred many months before it's typically discovered. And it's because the cyber attacks, the attackers have a lot of patience to it, so it doesn't happen immediately, typically. And if you follow some of the more recent cyber attacks as well, they find out that this person, it was a vendor that came in maybe remotely and got into access the protected computer system, and the information extractor was on this independent contractor's computer that then was able to extract information to work their way up the food chain and management of a particular business until they got to the C-suite, essentially, in a lot of cases. So it's constant battle against them because they are very creative, and we are assertive. And I've been caught. I was in a rush, and I still have issues with our IT people because I'm very embarrassed that this happened. But my Amazon account I use my personal email, and so I was in my office rushing through stuff, and it was around Christmas time, and my credit card was just melting essentially, and Amazon this, Amazon that. And actually it was during COVID, so it was sort of like, okay, our Amazon purchases were amped up already, and I was like, okay, screen pops up and says, we're having an issue delivering this item, we need you to verify. And I'm like, fine, whatever, who bought what? And again, the embarrassment is that I was blaming my wife or one of my kids for just going nutso with my credit card. And I shouldn't say my credit card, it is our credit card. All of our accounts are marital family accounts. So it should say that very clearly. So it pops up and I click the button, and then it pops up, okay, this was a test of your Shumaker IT team and you have failed miserably. And, you should not click things that are wrong. And they had shown me the various things that should have alerted me to it being incorrect. And it was, first of all, like things like they said Joseph. No one calls me Joseph except for the IRS. So that was there. It was my work account. Somehow they knew that I don't do Amazon shopping on my work account, probably because they have my, Google history, which also was disturbing, but very clear that this is firm property. And that's also something else that while I'm saying it, is that you need to be clear with your employees that yes, you use your work email, you use your work assets, then there is, the rules of privacy are out the window. And that's not the reality. I mean, there is some privacy. So for example, if someone logs into their Gmail account on one of your work computers, there's a question as to whether or not that is private information. When you then retrieve the computer because you have fired that person for whatever reason, and their Gmail account is still running in the background on that seized computer, which I've had happen before, and have had to have discussions about whether or not we can use that information that showed that that particular person was already violating his non-compete 4 months prior to being terminated, and when we found out about it. So
Wow.
all kinds of interesting things happen. But
Hey, I got a question for you.
Sure.
Which does not necessarily pertain to trademark, but it does to patent. And so in both cases, it seems like you got to have money to defend it. And, an ounce of prevention is worth a pound of cure. But a lot of times the bullies that have the big war chests always win. And not always, but you have to defend yourselves. So my father-in-law was a field test engineer for a large privately held manufacturing company of farm equipment. They were the ones that first invented the baler and the round bale, right? And so John Deere, which I had an affinity for because my grandfather wouldn't run anything unless it was John Deere, but they're known as being bullies, and they've got big war chests. And so they completely stole my father-in-law's patented machinery, and they just ripped it straight off, and they're known for kind of doing that, evidently. Well, so his company had to defend themselves, and they had to go after John Deere, and it was his field test notes, that beat and took down John Deere, which is pretty cool. But it still cost that company a ton of money because John Deere wanted to just grind them down. And I hate saying that because, again, I do have a personal affinity for green tractors because that's what I grew up driving. Well, in that case, if somebody infringes upon your stuff, you go to war, you have to spend a king's ransom to defend yourself. What are the chances of getting, compensated back from the losing, in this case, John Deere?
So at some point, they're going to say, well, it's the thing about patents, and the way I describe it is, imagine there's 10 steps to do something. And if you can remove step 7 and 8 and substitute something else, have you violated that patent because you actually are doing something different? And obviously step 7 and 8 would have to be something substantial in getting to, but you end up at the same result. And so that is the fundamental issue with patents and protecting patents. But it's, those kind of things, as you've described it, sounds like, okay, it became clear that it was a ripoff. And so in the beginning is, well, defendable because there's differences of opinion. And I think as time goes on, where it becomes obviously willful infringement and they continue to sell those things, then that's where you can say it's willful, in the statute. The federal statute provides for compensation in the form of punitive damages, but also in the form of recovery of attorney's fees. And so then you have the ability, in punitive damages are like 2x, 3x of the actual damages potentially, but it's all in the judge's discretion. That's also an issue. But I'll give you another example. So we went, my colleagues down the hall here in our IP group went head to head with Walmart on a grill that they had ripped off, essentially both design, but also the name. And they fought it and fought it and fought it. And they were losing at every level, and they were being creative, and they spent millions of dollars in attorney's fees. You might imagine what the fees were on our end as well. And in this instance, it was a client who had the ability to fund it and saw it on a matter of principle, essentially. But then what was happening is we were winning the small battles, and but they were very obstinate, arrogant, and they continued onward, and we demolished them. It took many years. They went through many attorneys and law firms that weren't doing what they wanted them to do, meaning winning. But they kept appealing, and they kept, little nuances and procedure things and this and that, and they were fighting on multiple levels. So not only on the trademark infringement, but also, other processes and procedures. And they were filing things in state court that then we had to fight and say, well, no, this is part of the larger case, so it needs to be put back into federal court so that the judge who is hearing everything else can hear this. And so, all those things, just, the money machine is just running and running and running and running. And they kept selling this thing in the Walmarts. And so it became a matter of, okay, and then now, because it's willful, you get to pay us a royalty for use of the name for your sales. Not everything. I mean, they still had cost in producing and shipping and distributing and everything else, but they had to pay our client a substantial ransom for continuing to use something that was deemed to be willfully infringing upon. So that is the minority of cases. I mean, it's David versus Goliath. And, and he was using his winnings. So there were some wins that Walmart had to pay certain fees to us, to our client, that was replenishing the war chest, which is also unusual. So in your case, with your father-in-law's case, yes, at the end of the day, it turned out well, but financing that fight against the Goliath is usually an issue.
Yeah, it's a real deal, and it's terrifying because if you got money and you're a bully, you usually win, which is really sad. But I love it when David does win.
Yes. And the thing also is there's a lot of intellectual property that surrounds us in our businesses. And it's a matter of, should we protect those things? Whether it's a product name, it's like, why it's expensive to do that. The reason being is that if you develop that product or that service, at some point someone will say, man, that's a great idea, I'm going to leverage off of that. And, I know that I can manipulate the Google searches so they find me and I can outprice them, or, whatever it may be. So it is someone who's looking for a service and they live in, let's say, Fort Mill, and they just do a search for Charlotte, where your business is located, but Google knows that they are located in Fort Mill. Then maybe that Fort Mill entry in Google comes up first. And again, Jack theory, I don't know how all that stuff works. And even if I did, they change it all the time, the Google algorithms anyway, in order to keep money flowing as to, now I got to pay this fee in order to stay on the first page of Google. They change those algorithms all the time. So, it's a lot of craziness out there with Google and paying, but protecting your trademark is important, because then you can go to Google, and again, that's not inexpensive, because I've gone through that process, and saying, hey, this person is violating my trademark by selling this stuff. I've had to notify Amazon to take vendors off because they were infringing and having to go through that process. And it's not, it takes a long time. You know, Amazon and others are, I shouldn't say unwilling, but they are very slow moving, because you imagine they get these requests all the time of, hey, this person violated my, is infringing on my intellectual property. You need to shut them down. Maybe, but you know, prove it. And the proving takes a long time to do. So, but that doesn't mean that you shouldn't get it in the first place, because if you don't have that weapon, then I can't write a cease and desist letter. Like someone says that I've been using this mark forever. And I would rather you have a federal trademark registration to use that as a weapon, because then what happens is, first of all, you should be using the R in a circle for registered marks and the TM symbol for marks that you're saying is my mark, but I haven't registered with the feds yet. And so by you doing that, that puts them on notice. So this whole issue of incidental infringement, I say, well, you may not have noticed. So again, sarcasm, maybe condescending, but I do it anyway. You may not have noticed that there is a TM or an R next to our mark. What that means is this. So yes, we're asking you to cease and desist, and you know, please respond. And now they're on notice. So now, from my perspective, if they continue to use it, now it's purposeful. Now I'm in that statutory section that says treble damages, attorney's fees, et cetera. And I can use that as a weapon. Now, many times, you know, how effective is that? It's like, okay, well, they're already in trouble. Is that going to make them change? In some cases, it does. It is, okay, well, I don't want this to happen. So it's easy for me to just basically say that's a sunk cost in all the collateral that I've printed and put up, and I'll change my website. Just give me 30, 60 days to do it.
Yeah, we've had to do that already a few times on anything but typical, based on other CPAs that like, hey, that seems to work. Well, we spend a fair amount of intellectual property time and doing it, and so we did have to do that. One final question before we wrap it up, and if anybody else has another question, hit us up now, because time is wasted. But what about all of the proliferation of all the foreign entities? And let's just call a spade a spade. China is known for ripping off stuff, you know. There's a lot of IP that gets ripped off by China, and there are other bad actors out there, I'm sure. But what, if anything, can you do as a U.S. company?
So the answer with respect to goods that are sold in China is very little. The answer to what is sold in the US, and you have Chinese knockoffs coming to the US, you can take a federal, I feel like I prepared you for this question, but no, I mean, I didn't. And it's a great question. So what you do is you take your federal registration and register it with the US Customs and Border Patrol. And when as they're coming through and it's becoming more automated, they see something and like, wait a minute, this is a problem. They will embargo those goods, and they're supposed to notify you that, hey, we believe that there is an issue. Please contact us so we can discuss it further. Now, the reality with budgets and everything else that's going on, and you know, them dealing with people crossing in rather than stuff crossing in, you know, you have to deal with that bureaucracy and everything else. But I think that as they continue to automate it, you have a better chance of protecting infringing goods, the copycats, from even getting into U.S. jurisdiction by being stuck in a warehouse somewhere that is run by Border Patrol. But great question.
Yeah, you didn't prime me. I hadn't seen any of your slides. Just a curious business owner that has been around the block more than a time or two. Any other final questions from the gallery? This has been an interesting conversation, so I really appreciate it. Next week we'll have Adam back, Lord willing. I think his wife did a secret Shanghai, which is kind of cool. So anyway, hit us up on next week. We will put this up on the BGW YouTube channel later on this afternoon. Thank you guys for joining us, and thank you, Jack. It's always interesting. And don't forget Bruce Anderson, because he was the Google, he guessed it right. He knew it. So
I wrote it down. I wrote it down so I wouldn't forget.
all right.
But Bruce, if I happen to forget, feel free to tell me to send you the card. No, no shame in doing that. But I will get that to you.
And good questions from Robert. I would have been disappointed if you weren't asking good questions, but those were good and insightful. So anyway, thank you guys for taking time out of your day. And it looks like the clouds are going to break here in Charlotte, North Carolina, and another day of spring is going to bust out again. So enjoy the day. Take care, y'all.
Thank you.
Bye-bye.